IP comes in all of this. IP comes in all that, like what we start creating to have business advantage, to have competitive advantage. Now, there are aspects related with patents. Many times, like when you say IP, we start associating with patents, which protect the technology concept that is behind this or that is used for the creation of such a product or system. When you start looking at what's the IP when I'm configuring a system, or what's the IP when I'm designing a particular system, is it just about changing certain things, or particularly in the design, the rules of the designs are often like well established. So have I created a system or a product by just using the rules which exist, or have I contributed something new to the rules of by which I can now design? I see a lot of development happening even here, because with if from different disciplines, we have like created this whole what used to be a very simple way of configuring. Today it's like a lot multidisciplinary in nature thing. There are a lot of things that we have borrowed in. So there may be technology concept here. There may be certain things which may look like fine, I've just used some well-known principles, or I've used some standard to go and create something. But there may be again certain, if you look closely, technology concept that has helped us differentiate what we provide as a value with what's already available in market or what somebody else is providing. We need to pay attention to all this creation. It may be an electronic circuit that I have created or designed, but even here, the way I have like gone about this creation, we start examining that. It's quite possible that there is a patentable subject there, or there may be something which we start creating features which is more of the industrial design comes under this design protection. How a product will start looking like. In some jurisdiction, of course, how a product is going to look like in the computer screen is also adding value to the customer. And there is good debate there is, okay, can we protect something? How my product start looking in a computer screen? Can design apply there? Or trademark, can we trademark? Is there a trademark aspect comes in when we have a particular way in which I represent my system, or I design my system from a look and feel aspect? There is, of course, a lot of things in which the manner in which we are working, the trade secret aspect comes in. Something which may feel, okay, look, this is giving us advantage, but this is not something which gets protected in a very strong manner through patent or design, but it gives us a strong competitive advantage, and therefore we start to look at, is this aspect something which can qualify or which we could benefit by maintaining it as a secret? And of course, we need to take steps there. There are certain, legally there are certain definition as what's a trade secret, how should we manage it. We start paying attention there. The way we would name our product or the system, even there the trademark aspects is there. How we manufacture, all these aspects which I mentioned about, it may look like a manufacturing as a routine technique, but there is a lot of things, a lot of insight that has gone in on how do we make sure that day in, day out, the quality is maintained, or I am able to work, or we are, as an organization, we are able to work in an efficient manner. There are a lot of know-how that resides there. So these aspects, we need to pay attention and see what's a suitable way of protecting them, identifying and take steps to protect them. So I'm sure whatever product, however simple it may look like or complex it may look like, whichever may be the scenario in which we are operating, there are so much of IP which is embedded there. or if it's a new creation or a product development activity you're doing, there's so many things that can be identified and look for protection. There's a strong need that we identify this and protect it for the advantage which SK and which was brought out, like what's required for funding aspect or sustaining business. So more later.
Yeah, sure. Yeah. Thank you, sir. That was quite insightful. I would like to ask you one question, Mr. Moti, specifically. Senthil sir said about how it's not like we don't have any individual systems acting all alone today. We have, if anything today, we have all the more systems interacting together. So how important is when it comes to finding out some kind of a standard with respect to patents? So we would like to hear a bit about that, please.
Okay. Standards is a very important and very controversial topic to all over the world. What I mean by standard is, I'll pick the most controversial area of standard so that the effect is felt and we really know what's happening, right? If you look at Wi-Fi standards or cellular standards, we have IEEE as an organization, standard settings organization, which will formulate standards with the cooperation from many players, right? These players could be competing companies, and ETSI and 3GPP are standard settings organizations which would set standards for cellular standards. And if you look at standards technology, this is how a standard would be formulated at a very high level. Several players come together, and these players could be competitors. They come together, and once they identify an issue, then they try to solve it by bringing in their technology to the table, right? And this technology could be protected by patents for each of these companies, right? So one of the motivating factors for the competing organizations who take part in standard settings process is to include their patents or include their patented technology into a standard. Why? Once it becomes a part of a standard, then there will be umpteen number of people, umpteen number of manufacturers who wants to manufacture standards compliant products. And if they have to manufacture standards compliant product, they have to use the standard essential patents which belong to the standard setting, standard essential patent holders, right? So all of a sudden, once your patent is included into a standard, or once your patent becomes a standard essential patent, you have an opening for a very huge market. There are so many people who want to implement this, right? And because of this, you are in a position to collect royalties, right? You are in a position to collect royalties. If you had a proprietary patent or a conventional patent, there could be 5 licensees who would want to implement it. But if the same patented invention becomes part of a standard settings process, and if it becomes a standard, there could be 1,000 people who would want to implement, right? So the value of the patent or the innovativeness of the patent did not change. The value of the patent did not change. But by putting it into a standard, the access to the marketplace has become completely different. And once that happens, there are angles or there are issues from the competition law, right? And you are controlling the market because of under a scanner, and how you behave becomes very important. So to ensure that standard essential patent holders behave well, standard settings organizations have come up with principles. At least 70% of the standard settings organizations in this world have come up with a principle known as FRAND, F-R-A-N-D. F stands for fair, R stands for reasonable, and ND stands for non-discriminatory. But the irony is FRAND is not defined anywhere by any standard settings organization or by any courts in any part of the world today. FRAND is not known. It just says FRAND, but what does a FRAND stand for? What does a FRAND mean? What should be the reasonable royalty is not decided yet, but are defined yet. There are some court cases. For example, if I may quote Microsoft versus Motorola Mobility, when it comes to Xbox, Motorola Mobility asked Microsoft to pay around $4 per Xbox that is being sold by Microsoft as a royalty. And Microsoft said it is too high, and they took Motorola Mobility to the court, and the courts in the US decided that the actual reasonable royalty, I should not say actual, the reasonable royalty is 100 times less than what was sought by Motorola Mobility, right? So finally, Microsoft, instead of paying $4 billion to Motorola Mobility, they ended up paying few $100 million as the reasonable royalty. So on one hand, I'm saying that there has to be a strong protection for patentees, and on the other hand, I'm also saying that there has to be a balance between the rights of the patentees and in this particular case, standard implementers, and which would eventually benefit the consumerism, right? So that's about standards.
Thank you, sir. I would like to ask you this question, Mr. A.R. Jayakumar. We actually have a lot of entrepreneurs out there who are doing R&D. So we would like to understand about the different incentives and schemes available to ESDM companies in our state of Karnataka. So you will be the best person to answer that, I feel.
See, this Karnataka government through KBITS, Karnataka Biotechnology Information Technology Society, they give a lot of incentives to ESDM companies registered with them. One of the major incentive what they give is for patent registration itself. So whatever patents you have registered, Indian patents which you have registered in India, patents registered in India, they reimburse the expenses up to 1 lakh. And whatever patents you have registered internationally, they reimburse expenses to the extent of 5 lakhs. So that is one of the incentives state government is also giving. In addition to that, state government gives, or the same KBITS gives a lot of incentives for capital expenditure, capital subsidy, up to 1 crore, whatever investment you have made, each company 25% of the investment or up to 1 crore they give an incentive. Then they give reimbursement of expenses you are tapping international market for your travel expenses. Then suppose you put a trade show, you participate in a trade show, you put a stall there. So expenses up to 10 lakhs per year they give as a reimbursement if you are participating in international, for tapping your international market. Then in addition to that, they give this, suppose you are incenting exporting your product, then they give this duty drawback schemes available given by them up to 25 lakhs. Then these are the schemes, major incentives which the state government gives through KBITS for ESDM registered companies. So I think all the people should avail these benefits, register your company there, including this is one of the incentives you get for registering your patent. Once you register your patent, once you get your expenses reimbursed by them, both for Indian patent as well as for international patent. Thank you.
Thank you, sir. I would like to ask you this question, sir. When it comes to applying for a patent, it is also very much important that we understand about the art in which we are going to apply for the patent, about what patents are already out there. And I'm sure ABB, who is into so many different aspects of engineering, it would be quite interesting to hear how that is being done in your company and what would be your advice for entrepreneurs and startup companies as well.
Right. So it's a good question. Patents or IP as such, one, it's a business tool. So we are going to use it for business. Now what does business mean? Business means whatever I'm developing, we talked about that we should be able to have protection that which I could make use to stop others from copying what we have done. So there's a lot of effort that has gone in the research phase. It has gone in understanding